Welcome, everyone, to the first and, dare I say, best final round of an international mock trial alumni contest flash trial competition. We began with 16 teams. They received a different case every round for 4 rounds in a row, only 1 hour to prepare, then they had to put on a full trial. They had a little bit more time for this final round, about 3, 4 hours, but we could not be more excited to see what these champions have in store. But who will judge? Who are the deciders? We're going to announce them step by step, beginning with Abygale Kim.
Hi everyone, my name's Abygale. I am a junior at UCLA. I've got about 7 years of high school and college mock trial experience. I've taught mock trial to middle, high schoolers, and college students. My message to the teams is go Bruins, you guys got this. It'll be really fun to watch you guys, and I hope you have as much fun as I do watching this round.
Next, Ayaan Bandukda.
Everyone, my name's Ayaan. I'm a high school competitor in Chicago, Illinois, and my message to you guys is just good luck. I mean, I've seen some really impressive stuff this tournament, and I know you guys are going to do great.
Mr. Daniel Chien.
Good afternoon, everyone. I'm a freshman competitor in the Modern Brain Mock Trial Nationals team. And my message to you guys is just good luck and have fun with the round.
Emily Michie.
Hi, my name's Emily. I compete for UCLA. My only message is thank you all for competing because I'm very excited to watch.
Jackson Calegari.
Hi, my name is Jackson Calegari. I am also at UCLA, a sophomore, and my message for competitors is despite all your national experience, this is the most important round you've ever been in. So I hope that you take it very seriously.
Caden Carr.
Hi, everybody. My name's Caden Carr. I'm a freshman at the University of Texas. I know that y'all are all great, and I'm really excited to watch you do what you do best.
Last but not least, Miss Vivian May.
Hi everyone, my name's Vivian. I'm a high school freshman, and my message to everyone is just good luck. You guys are going to do great.
My name is Ian Lampert. It's my honor to preside over this round. I do not have a ballot. The 7 individuals you just met will control your fate. With that in mind, good luck to all contestants. Let's get the show on the road. And can we get some preliminary matters, starting with appearances from the plaintiff?
Good afternoon, Your Honor. My name is Kole Alfonso, and I'm an attorney on behalf of the plaintiff in today's proceedings, Miss Katz.
Defense?
Good afternoon, Your Honor. My name is Nasier Muldrow. Today I'm representing the defendant in this case, the human yo-yo.
Any housekeeping from the plaintiff?
Just 2 matters, Your Honor. First, we'd like to move to invoke Midland's Rules of Evidence 603, 615, constructively swearing and sequestering all witnesses.
So invoked.
And secondly, Your Honor, me and Mr. Muldrow, we actually met before today's proceedings, and we've agreed to move all pieces of evidence, exhibits 1 through 8, to move them into evidence without any objections.
Okay, they're in.
With that, Your Honor, we're ready to go.
Anything from the defense?
Yes, Your Honor, just one thing. We just want to put the court on notice today. The defense is going to be pursuing an affirmative defense known as assumption of risk. And with that, Your Honor, the defense is ready to get this ball rolling.
Okay, let's get it rolling. Opening statements, starting with the plaintiff.
Yes, Your Honor, may I proceed when ready?
Please.
They didn't replace the rope. This is a case about negligence, where a bungee jump company didn't replace their rope, and someone got hurt because of it. Let's start over. It's April 30th, 2024, and Mr. Birdie is standing at the edge of the Devil's Drop. That's a bungee jump that's 300 feet above the ground on the side of a mountain. Now, Mr. Birdie, he's in his harness. His fiancée is right behind him, cheering him on, and he's seconds away from taking that leap. But what Mr. Birdie doesn't know, what he couldn't possibly know, is that the rope attaching his harness to that bungee cable, it was old. It hasn't been replaced. In fact, you'll learn it was 2.5 months past its warranty. So when Mr. Birdie leans forward and takes that leap, that rope snaps and he plummets 300 feet into the water below. It's a miracle that he survived. Which is why we're in court today. Mr. Birdie's fiancée is suing the owners of the Devil's Drop for negligence. Now, as the plaintiff, we have the burden to prove that it's more likely than not the case, 50% in a feather, that the defendant was negligent. Now, negligence, it's got 3 different elements. First, that the defendant failed to use reasonable care to protect Mr. Birdie. Second, Mr. Birdie was hurt because of it. And third, that Mr. Birdie getting injured was caused by the defendant not acting reasonably. Now, over the course of today's trial, we're going to prove those 3 elements through 2 simple facts. That rope, it was unsafe. That manager was uncertified. So let's take those 2 facts just one at a time. First, well, that rope, it was unsafe. You'll learn that the defendant knew that their ropes had a 6-month warranty. Every 6 months, you got to replace the rope. It's for safety. But what you'll learn is that the defendant chose to leave that rope 2.5 months past its warranty. Now, members of the jury, both sides, we agree that Mr. Birdie was 230 pounds at the time of this accident. You'll learn if the defendant properly maintained those ropes, if they replaced them, Mr. Birdie could have been 5, 10, 15, even 45 pounds over his weight. Because if those ropes are properly maintained, you'll learn that they can handle up to 275 pounds. But what you'll learn today, the reason that rope snaps, because it was past its warranty and it was just unsafe. Which brings us to our second fact, that manager was uncertified. It will bring you the defendant's safety certification, and you'll see for yourself that it was expired. And we're not talking by a few days or a few weeks. It expired 2 years prior to Mr. Birdie getting on that Devil's Drop. And members of the jury, you'll get to hear from Mr. Birdie's fiancée, who was there that day, and she'll walk you through everything that happened. And she'll tell you, she had no idea that that rope was 2.5 months past its warranty. That she had no idea that manager's certification expired 2 years ago. That she had no idea. She was going to watch as her fiancé plummeted 300 feet because that rope snapped. Now, members of the jury, I expect that throughout today's trial, and perhaps even in a moment, you may hear that it wasn't this company's fault. You may even hear it was Mr. Birdie's fault, that he knew what he was getting into. What I want you to keep in mind is that no matter what Mr. Birdie did that day, if this defendant had replaced their rope, we wouldn't be here today. Which is why at the end of this trial, we'll ask you to find the defendant liable for negligence. They just didn't replace the rope. Thank you so much for your time.
Thank you, plaintiff. Defense, please proceed when ready.
He wanted to redeem himself. So he took the risk. You see, Mr. Alfonso, he just got up here and he told you about what happened on that day. He told you about a rope. What you're going to learn today is that this case, it comes down to a hope. A hope that the plaintiff wasn't overweight. Let's take it back a couple months. You see, the plaintiff, he's just got home from a long day. He's stressed out. The first thing he does is he goes to the fridge, he opens it, he grabs something, and he leaves. But you see, he comes back, opens the fridge, grabs something, and leaves. He does it again. And again. Members of the jury are going to learn today he had an eating disorder, that he gained nearly 80 pounds. This wasn't the life he wanted to live. See, he used to be adventurous, cliff jumps, free falls, everything. This isn't the life he wanted for himself anymore, and this certainly wasn't the life he wanted for his fiancée. So you'll learn he recently proposed. And to celebrate that, he takes them to Devil's Drop. And when that day comes, it's his turn to go. But he hesitates. You see, he knows he's overweight. See, in front of him is a sign that reads, weight limit 225 pounds. But you see, behind him is his fiancée. He struggles with this decision. Redemption or risk. The evidence is going to show he jumped. The evidence will show he was 230 pounds, just like Mr. Alfonso told you. He wanted to redeem himself. So he took a risk. You see, members of the jury, when the plaintiff, they turned on their screen and they started talking to you, there was something unique about the differences between us. You see, the plaintiff, they have a burden of proof to prove to you more likely than not that my client, they were negligent in their care, that they were so unreasonable, no other company would have done that. And they're not going to meet that burden. But you see, the defense has done something of their own. We've elected to pick up an affirmative defense known as assumption of risk. And I know assumption of risk, that is not language we use every day. But it's as simple as this. When somebody knows the dangers and risks of an activity they're going to do, but they still choose to go through with it, the law is going to tell you you can't go and blame somebody else for what happens. And we're going to prove that to you through three really simple facts. First, he was over the weight limit. Second, he knew he was over the weight limit. And third, he still jumped. Let's take those one at a time. Let's start with the first one. He was over the weight limit. And Mr. Alfonso and I, we actually agreed on this. He told you it. He was at 230 pounds. We'll even show you the incident report for after. It's going to read he was at 230 pounds. That brings us to the second fact. He knew he was over the weight limit. See, now this one's really simple. We're going to show you a really big sign. It's right outside Devil's Drop, and it's going to say weight limit, 225 pounds. Don't go on this. In fact, his fiancée is going to take the stand. And she's going to have to admit to you that when he was asked about his weight, he didn't just say it. He hesitated. That's going to bring us to that third fact. And he jumped anyway. And this is undisputed. We know he did it. The question is really going to come to why. In fact, we're going to show you the liability release waiver form. It outlines the risks, the dangers, that height, everything that has to go with that devil's drop. You'll learn he grabbed a pen and he signed it. He wanted to redeem himself, so he took the risk. And members of the jury, what happened in this case is tragic. Him falling from that height and sustaining such damages and being still alive, we're grateful. And we understand if you have sympathy for them, but for you to go as far as to blame somebody else for a risk they accepted, the law is going to say you can't do that. That's why at the end of today's trial, I'm going to come back before you. I'm going to ask that you find them not liable. Thank you so much for your time.
Thank you, defense. Plaintiff, please call your first witness.
Yes, Your Honor. Plaintiff calls Miss Katz. May I proceed, Your Honor?
Yes.
Good afternoon. Please introduce yourself.
Good afternoon. My name is Marley Katz. It's a pleasure to meet you.
Where are you from, ma'am?
I'm from this little town in Georgia, Atlanta, if you ever heard.
Ma'am, what do you do for work?
I teach third grade at Booker T down the street. Ever since my fiance stopped working, I also picked up some extra shifts, working at the after school too.
Who's your fiance?
Charlie Birdie.
How'd you and Mr. Birdie meet?
Back in 2017, so about 8 years now, I was at this rock climbing gym, and this guy just comes up to me, taps me on the shoulder, says, "Race ya," and then starts sprinting towards the nearest wall. I got mad, said it wasn't fair because he had a head start, and he said he'd apologize over dinner. And things just happened.
Ma'am, you told us Mr. Birdie wasn't working anymore. Why not?
We went bungee jumping together in August of last year. He got hurt, so he couldn't work.
Ma'am, why would you go bungee jumping?
He actually proposed a few months before that, and he said that we could go bungee jumping to celebrate. He promised that whoever won got to choose the cake. I didn't even know you could win at bungee jumping, but I'd follow him anywhere, so I went.
And ma'am, I want to talk about that day. Where were you bungee jumping?
We were doing the dive for the human yo-yo.
Ma'am, what's the human yo-yo?
They're this extreme sports company. They do things like skydiving, cave diving, bungee jumping, of course. Around where I live, they set up shop near these cliffs. They give you the people and the staff and the equipment that you need to jump.
Ma'am, on August 30th, who was working there?
There's just one person that I remember. This tall fella, dark hair. I think he had this name tag, said Jackie.
What did this Jackie fellow, what'd he do?
He had us sign the waiver, walked us through some of the steps, and then he helped us with our equipment.
Your Honor, at this time we'll be sharing what's already been entered into evidence, Exhibit 1, that waiver. Just one moment as we share this.
Happens to the best of us.
Yes, it does. All right, ma'am, is this the waiver that the defendant showed you?
Yeah, this is the one that Charlie signed.
Ma'am, can you tell us what this waiver, what it says?
The usual things. It says that bungee jumping, like anything, is it's dangerous. It says that we acknowledge some of the risks of it, and it makes sure that we did everything correctly, that we don't have any conditions, and that we've been instructed.
Ma'am, does this waiver say anywhere that the defendant's jump master hadn't been certified in 2 years?
No, it doesn't say that.
Does it say anywhere in this waiver that you and your fiance signed that their ropes haven't been replaced in 2 months?
No, sir, of course not.
Does this waiver warn you that if those ropes aren't replaced, they could snap?
No, sir, it doesn't.
Ma'am, what does this waiver say about the responsibility of the defendant's company?
On the second page there, it says that they'll provide compliant equipment and certified jump masters.
Ma'am, with that in mind, I want to talk to you about what happened when you used the defendant's rope. Ma'am, after you and your fiance signed that waiver, where did you go?
We went to the cliffs. Jackie, the staff member, he helped us with our equipment and our ropes.
Who went first?
Charlie did. Tapped me on the shoulder. Said, "I'll race ya." Just started sprinting towards the edge.
What did you do?
I chased after him. I said it wasn't fair that he got a head start again. But by that time, he had already jumped.
Did you jump too, ma'am?
No, I didn't.
Why not?
I was going to. I was gonna follow him, and then I heard this sound, like some kind of crack or some kind of snap, and I stopped and had no idea what was happening. And then I saw the rope come back up, and I didn't see Charlie anywhere.
What happened to Mr. Birdie?
I don't even know. We found him at the bottom in the river. He was hurt real bad, and he's doing better now. It's not the same.
Ma'am, did you ever get a chance to see what happened to that rope your fiance was using?
Yes, sir. It snapped.
Thank you so much for your time, Miss Katz. Your Honor, nothing further.
Thank you. Cross-examine.
Yes, Your Honor. Ms. Katz, I want to start off by saying I'm so sorry about what happened to your husband.
Thank you, sir. I appreciate that.
Let's start off pretty easy. Let's talk about what Devil's Drop meant for the both of you. Because, ma'am, it's true. You described the two of you guys as being pretty adventurous, right?
Yes, sir.
You guys would do cliff jumps and free falls.
Yeah, he was the person I wanted to go on all my adventures with.
And at the time you guys first started getting together and doing those things, you actually described Chuck as being pretty lean, right?
Back then, yeah.
That's right. That was back then. Things changed, right?
I mean, yeah, it's normal. He just got busy with work, put on some weight for sure.
Ma'am, it wasn't just normal. You'd say your husband had an eating disorder, right?
Yeah, it turned into that.
He would binge.
Yes, sir.
He gained nearly 80 pounds.
He did.
But then, ma'am, it's true. Your husband, he started to get better, right?
Yeah. I don't know, maybe it was work, maybe it was something else, but he started being a little bit more like the Charlie I used to know, more adventurous, more happy, I guess.
I mean, he even proposed to you, right?
Yeah, he did.
And Devil's Drop was supposed to be the celebration of his recovery and your guys' proposal, true?
Yeah. He said it was like we'd be diving into our new life together or something. I don't know. He's corny like that.
Let's talk about if Mr. Birdie had recovered enough to actually do Devil's Drop. Because it's true, man. Right outside of Devil's Drop, there's a big sign, right?
Yeah, there were a lot of signs there.
You'd recognize one of those signs if I were to show them to you?
I reckon I would, sir.
Your Honor, at this time, we're going to be displaying Exhibit 5. It's one of the signs at Devil's Drop. It's already been pre-admitted.
Okay.
Ma'am, this is the sign you saw, right?
Looks like it, yeah.
It says, attention, weight limit 225 pounds, right?
Yes, sir.
It says for your own safety, do not enter if you're over that weight limit, right?
Yeah, that's what it says.
But it's true, that wasn't the only thing reminding you guys about weight, true?
It was on the waiver too, if that's what you're talking about.
That's right, ma'am. There was a waiver the two of you guys signed, right?
Yes, sir, there was.
That waiver had outlined the risks?
The risk of bungee jumping?
Yes.
Yeah, it said that we were going somewhere pretty high. There could be things like weather, so anything like that could be risky.
Not just weather, it outlined the dangers of it too, true?
Yeah, it said bungee jumping could be risky. That's right.
That waiver said you guys also signed a waiver away from negligence, true?
Yeah, I didn't really know what that meant back then, but that's correct.
Ma'am, let's talk about what happened when it was your turn to go up. Because, ma'am, it's true, when you stepped up, they asked you your weight, right?
Yeah, they did.
And very quickly, you said 148 pounds, right?
That's right.
And then it was your husband's turn to come up, and they asked him the same thing, right?
That's right, sir. And then he told them he was 221, I think.
Let's stop there for a second, man. Because before he said 221 pounds, you'd say you saw your husband hesitate, right?
Yeah, he stopped for a moment.
He stopped for a moment before he said 221, right?
Sure.
And after that, he said ratio, didn't he?
Yeah, he did.
And then he jumped.
Yes, sir.
Ma'am, sitting here today, you know your husband's weight. It wasn't actually 221 pounds, right?
No, I didn't know it then, but when we went to the hospital after, took him in, did the like a checkup, just height, weight. They said he was 230.
Ma'am, you'd recognize that incident report if I were to show it to you?
The hospital forms? Yeah, I would.
Your Honor, at this time, we're going to be displaying Exhibit 8. Again, it's already been pre-admitted.
Okay.
Ma'am, looking at that top right corner, it says they weighed your husband at 230 pounds, right?
That's what it says, yeah.
Ma'am, that's 9 pounds over the weight he told the instructor that day.
Yes, sir.
And that's 5 pounds over the weight limit sign we just talked about.
That's right.
Thank you so much for your time. Your Honor, we've got nothing further.
Any redirect?
Yes, Your Honor. Ma'am, Mr. Muldrow, we asked you about that sign about the weight limit. When you were there that day, do you recall seeing a sign talking about the defendant's certification status?
No, I don't remember anything like that.
Ma'am, do you recall seeing a sign talking about the warranty of the rope?
No, I don't.
Thank you, ma'am. Your Honor, nothing further.
Recross on those grounds?
Not at all, Your Honor.
That we ask for Ms. Katz to be excused.
Thank you very much. Anything further from the plaintiff?
No, Your Honor. Plaintiff rests our case in chief, and we're ready to move right into defenses if Mr. Muldrow is willing.
Defense?
Very willing.
Okay, let's do it.
Yes, Your Honor.
Your Honor, at this time, defense is going to call Jackie Bondier to the stand. Could you please introduce yourself to our jury?
Of course. Hey, everyone. My name's Jackie Bondier.
Mr. Bondier, what do you do for a living?
I'm the Chief Operations Officer for a company called Human Yo-Yo. And I get it. Pretty weird name. We don't actually sell yo-yos. What we do is extreme activities, things like skydiving and cliff jumping.
Sir, how long have you been working for the Human Yo-Yo?
Let's see, I got my master's in business administration in 2010. So I guess it's been about 15 years now.
Mr. Bondier, can you describe just how you're involved in this particular case?
Of course. I was the working attendant at the Devil's Drop attraction we host the day that Mr. Birdie came. I walked him through his safety procedures and helped him with his liability form.
So let's start by talking about the safety procedures you have in place for Devil's Drop. Before we jump into it, can you tell us a little bit about what type of attraction this is?
Of course. Devil's Drop, it's a little bit in its name. It's our highest drop for bungee jumping. It's a 312-foot drop, so, a little bit more than the size of a football field. It's pretty far down.
Sir, for Devil's Drop, do you have a safety compliance system?
We do. So for bungee jumping, there's really two things you have to make sure you have. You have to make sure the equipment is checked, and you have to make sure your instructors are properly trained to do the harnessing. We also have our customers sign a liability release form. That way they know what the risks are associated with bungee jumping.
And sir, on those instructors that you mentioned, how much training are they required to receive?
Well, in order to become an instructor, you have to do 500 supervised jumps with an already certified jump master. At that point, you become a jump master and you're able to do it on your own. I was a jump master when I started for the company and did it for about 10 years.
And you mentioned a little bit about equipment. How often do you check the equipment at Devil's Drop?
We check our equipment daily, but the ropes themselves, they have to be replaced every 6 months for wear and tear, and we do that as well.
Sir, those ropes. What is the weight limit for those ropes?
The weight limit that we're comfortable with for our Devil's Drop is 225 pounds. That's what we post outside the drop.
Sir, would you recognize that sign if I were to show it to you?
I would.
Your Honor, at this time, we're going to be displaying Exhibit 5 again. It's already pre-admitted.
Okay.
Sir, where is this sign at?
So this sign is posted right outside Devil's Drop, right there on the wall when you walk in.
And sir, in your 15 years at Human Yo-Yo, have you ever had a rope break?
No. In the 15 years since I've been with Human Yo-Yo, we've never had a rope break.
In your 15 years, have you ever not replaced a rope?
No. We replace the rope every 6 months, just as regulation requires.
All right, thank you so much. You can take that down. Let's move on to talk a little bit about the liability release form.
Okay.
That's your top customer sign. Would you recognize this one if I were to show it to you?
I would.
Your Honor, at this time, we're going to be displaying Exhibit 1A or 1B, 1B in this case.
Okay.
Sir, well, what is this?
So this is the liability release form that I walked through with Mr. Birdie when he came for Devil's Drop that day.
The same way you walked him through it, could you walk us through a little bit about this form?
Of course. So the most important section is going to be that first section titled Assumption of the Risk. In that section, we go over the nature of the activity, which if you see in that first bullet point there is bungee jumping with a height exceeding 300 feet.
And what are some of the risks of bungee jumping that you guys detail in this form?
Well, if you see right below that in the paragraph that starts with I acknowledge, we talk about the risks of paralysis, injury, and in the worst cases, death, depending on what goes wrong.
Did he sign it?
He did. As you can see here on Exhibit 1B, right there at the bottom is his signature.
So as you were scrolling, I actually saw a weight on there, 221 pounds. So how did that number get there?
So the weight that we put on the forms is actually self-put by the customers. How it works is the customer brings up the form after they fill it out and sign, and I ask them for their weight. We actually have on site a scale that customers can step on if they want to make sure what their weight is if they're unsure.
So do you have any doubts about that number?
Initially, yeah. I mean, Mr. Birdie was a tall guy. He was over 6 feet tall. He had pretty, broad shoulders, but, I didn't ask any questions.
So why didn't you question him about it?
Well, I was talking to Mr. Birdie beforehand with his fiancee, Miss Katz, and they told me they were experienced adventure seekers. So I trusted that the number he would give me wasn't the wrong one.
So after you trusted that the number he'd give you wasn't the wrong one, what did you see Mr. Birdie do?
Mr. Birdie took the pen and he signed the document.
What did he do after?
I pulled him over to the area. I helped him with his harnesses, went over all the emergency safety procedures, and then he jumped.
Thank you so much for your time, Mr. Bondier. Your Honor, we've got nothing further.
Thank you. Cross-examine.
Yes, Your Honor, may I proceed?
Please.
Good afternoon, Mr. Bondi.
Good afternoon. I love this part you have with your hair going. I wish I could do that with my hair.
Oh, someday, sir. Sir, I want to jump right in and talk about you, all right?
Okay.
Now, sir, you're the COO, right?
Yes, Chief Operations Officer. I run all of our operations, including the attraction, Devil's Drop.
And now in your conversation with Mr. Muldrow, you say you do two main things.
Yes, the safety procedures and making sure we're in compliance with regulations.
Right, making sure your employees are certified.
Yes.
And making sure your equipment is safe.
That's right.
Let's take those one at a time, starting with your employees. Sir, August 30th, you're working that day, true?
Yeah, I was there doing customer satisfaction surveys, talking to customers as they were going, and I was working there doing the liability release forms.
And while you're working, you see Mr. Birdie walk in.
I do.
So I just want to make something clear. You hire trained professionals to help customers like Mr. Birdie.
With the liability release forms?
With the training and the harness, sir.
So we have jump masters that are on site that have to be certified with their training. That's the 500 supervised drops I was talking about earlier.
That's right, sir. But those jump masters, they're out on lunch.
Yes, that day they're out on lunch and I was manning the stand on my own.
So, sir, when these trained jump masters are out on lunch, you don't call one of them back and say, hey, we've got a customer.
No, I was doing customer satisfaction surveys and I was manning it on my own.
You don't tell one of those trained jump masters with 500 plus jumps that they have to come or Mr. Birdie's going to have to wait.
No.
Now, sir, you don't just handle his paperwork, right?
No, I set him up with the harness and made sure he was safe for the jump.
That's right, sir. Not a jump master. You handled that equipment yourself.
As I said, I was a jump master for about 10 years. I handled it that day.
Mr. Bodier, a very simple question, yes or no? You are not a certified jump master.
No, I've since promoted. I'm now the chief operation officer for the company. I run all of our safety compliance and standards for all of our attractions.
So, sir, your jump master certification expired 2 years prior to August 30th, right?
Yeah, they have about a 10-year window from my understanding. When I was chief operations officer, I didn't get it renewed.
So, sir, as you were COO, you didn't have that renewal. You still worked on Mr. Birdie's equipment, true?
That's right.
All right, well, sir, let's talk about equipment. If there's one thing you and I can agree on, you have to replace the ropes, true?
Yes, regulation requires that every 6 months the ropes have to be replaced.
Well, sir, as regulation requires those ropes to be replaced, well, you have to test them to be sure, right?
Right, you test the ropes for their grip strength.
Well, sir, you know those ropes have a maximum grip strength of 275 pounds, true?
It can. That's the highest we've had it tested at, but we're not comfortable with that number. That's why we post the weight limit of 225 pounds.
Well, sir, I'm not asking about what you're comfortable with. I'm asking about the maximum weight for those ropes. And you'd agree with me. It's 275 pounds.
Yes, it can go up to 275 pounds.
But sir, you know those ropes, well, as you said, they can wear.
Right, you got to replace them.
They can tear.
They can.
Now, sir, after repeated jumps, wear and tear, you know that those ropes, they can't hold as much weight, right?
That's right.
That's why you got to replace those ropes.
Yes, it's very important.
Well, sir, if this is very important, let's talk about if you did it. Your Honor, I'll be displaying Exhibit 2. Those are the records by Mr. Bodier's company.
Okay.
Sir, you recognize these, right?
Yes, these are the maintenance, repair, and report forms that we had before we switched to digital.
Well, let's walk through them. That first one, it's for May 22nd, right?
Yes, in 2022.
Sir, May 22nd, 2022, you replaced the ropes.
Yes, just as we always have done since I've started the company.
All right, so 6 months later, January, you replaced the ropes.
Yes, right on schedule, as you can see there. We actually had a couple days, I think, before the window was over. But yes, we replaced the ropes.
Sir, right on schedule. We can see it because there's a record of it. True?
Yes, our paper records.
All right, sir. So 6 months later, there's another rope renewal. True?
Yes, it looks like Daniel Lopez was the supervisor that day.
Sir, there's a record of it.
Yes.
And sir, the last record we have here, that's 6 months later. That's December of 2023. True?
It's December of 2024, but yes.
Sir, sitting in court today, you don't have any records showing you replaced your rope 6 months after that in June.
No, we don't.
Not in July.
No, we don't have the record for that.
Sir, you know Mr. Birdie jumped in August, right?
Yes.
So in those 8 months, December to August, you don't have a single record that those ropes were replaced.
No, we were switching to digital at the time and the record got lost.
So, sir, in court today, you're saying you just lost the record.
Yes, there was a mix-up in our system when we were transitioning from these paper ones to the digital ones, and that record was lost.
So, sir, after this record of this rope being repaired was lost, you know that Mr. Birdie jumps with your company.
Yes.
Under your supervision?
That's right.
Sir, you know that rope? It snapped.
The rope did snap.
Thank you so much, sir. Your Honor, nothing further.
Redirect?
Yes, Your Honor. Mr. Bondier, opposing counsel asked you about your jump master certification. Did that change how many jumps you led to get your certification in the first place?
No. Every jump master has to do their 500 supervised jumps at the start to get their certification. Since then, I've done a lot more since I was jump master for a while.
In this case, was Mr. Birdie's accident caused by you not strapping him in?
No, his harnesses were put on tight.
Was it caused by you not teaching him how to jump properly?
No.
What caused it that day?
That day, when Mr. Birdie jumped off Devil's Drop, the rope snapped.
And what was the weight limit you two had?
225 pounds.
Thank you so much, Your Honor. Nothing further.
Recross on those grounds?
No recross, Your Honor.
Okay. Anything else from the defense?
None, Your Honor. Defense rests its case in chief.
Would you like any time before closings, either side?
Your Honor, the defense is ready to get going. If they need some, I get it.
With that, we're ready to go straight to closings, Your Honor.
Okay.
May I proceed when ready?
Please.
They didn't replace the rope. Members of the jury, nothing lasts forever. That's why warranties exist. See, things wear and tear all the people, and to keep people safe, some things just have to be replaced. Smoke detector batteries. They only last so long. They've got to be replaced. Light bulbs. They only last so long. Someday they got to be replaced. Even milk. It only lasts so long. Eventually it has to be replaced. Same thing with ropes. Especially when a rope is supposed to catch someone hurtling down 300 feet off the side of a mountain. You learned today that the defendant's rope, it needed to be replaced every 6 months. But you learned it was 8.5 months after that warranty. 2.5 months after that warranty, it elapses. Members of the jury, every single jump, every single day after that warranty expires, it's just a ticking time bomb. Every jump, a tick. Another jump, a tick. Until 2.5 months later, that rope finally snaps and Mr. Birdie plummets 300 feet. They just didn't replace the rope, which is why we're in court today, which is why the defendant is being sued for negligence. Now, we told you at the beginning of trial that we have the burden to show you, more likely than not, that the defendant was negligent. Now, negligence, it's got 3 elements. The defendant failed to use reasonable care to protect Mr. Birdie. Mr. Birdie was hurt because of it. And that Mr. Birdie was hurt because the defendant failed to protect him. Now, to prove this to you, we walked you through 2 facts. That rope, it was unsafe, and that manager was uncertified. Let's take those 2 one at a time. First, that rope was unsafe. And members of the jury, we know it was. The defendant told you so. Take him at his word. He told you every 6 months that rope, it simply has to be replaced, no matter what. He told you after wear and tear, things happen, and that rope, it has to be replaced. Remember, you saw the records that his business keeps. They keep a lot of records. For the last 3 years, they have a record each 6 months showing that rope was replaced. But it just so happens the one record needed to show that that rope was replaced, well, it must have just got lost in the electronic shuffle of paperwork. Remember, jury, that's not reasonable. That's not how a reasonable person acts. A reasonable person keeps records. A reasonable person would replace the rope. A reasonable person takes the 5 minutes to replace that rope to make sure their clients are safe at all times. So why didn't this defendant just replace that rope? Because you learned today that manager was uncertified. Members of the jury, when you go back to deliberations, you'll have a chance to see this defendant's certification. You'll learn today it was 2 years expired. Now, Mr. Baudier, on cross-examination, he told you that it's just because he's now the COO. Remember, sir, you learned he was the one strapping Mr. Birdie into the harness and he wasn't certified for the last 2 years? What could he possibly have learned in those last 2 years if he took another certification course? To check if that rope is okay. To see how exactly long is he in for that rope for each day by day that goes by to make sure that rope is still safe, that it doesn't have to be replaced. We learned it was 2 years expired. Members of the jury, after this trial, I'm going to go eat at a restaurant. And if I sit down about to have my burger and a waitress comes on by and says, hey, by the way, that chef, he doesn't have his safety food certification. It expired 2 years ago. But you know what? Now he owns the restaurant. You're totally okay. Also, by the way, if you look above you, the chandelier being held by a rope, well, that's 2.5 months by its warranty. I'm doing one thing. I'm getting out of that restaurant. The difference in today's case is in that situation, I was told about the dangers. I could assume the risks if I chose to stay in that restaurant because I knew the risks. I was told Mr. Birdie was not. He had no idea about what could happen to him. No idea that the person putting him into that rope, Mr. Bodier, he wasn't certified. No idea that 2.5 months ago, that rope that would be his life-saving rope, it was past its warranty. He had no idea. Members of the jury, that's negligence. A company not telling a person about to trust them, trust their lives in them, not telling them, that's negligence. That's not what a reasonable person would do. A reasonable person takes the 5 minutes to replace the rope. A reasonable person tells Mr. Birdie, hey, by the way, I'm not certified. We should wait until a jump master comes back from lunch. That is not what this defendant did. But defense, they told you they've got a sign. You saw it today. 2 feet by 3 feet says the weight limit is 225 pounds. You know what would have been great? If a sign outside that establishment said, by the way, our ropes are 2.5 months past warranty. If there was a sign that said, by the way, the person strapping you into that harness isn't a jump master. Maybe, just maybe, if those signs were posted, we wouldn't be here today. But members of the jury, Mr. Muldrow and defense, they've sometimes in life you just got to call it like it is, and they are blaming the victim. They're saying Mr. Birdie, he just assumed the risks when he chose to jump off the side of that mountain. Members of the jury, we all know bungee jumping is dangerous. We know it could be deadly. Mr. Birdie assumed that risk. But if a person has no earthly idea what other risks exist out in the world, they can't assume that risk they don't even know exists in the first place. It's wrong. Because when defense got up here and said Mr. Birdie assumed that risk, that because he suffered from an eating disorder in the past, because he wanted to impress his wife, that's why he'd ignored and assumed all the risks that a rope could snap and a person was uncertified. They took on a burden themselves to prove that to you by preponderance of the evidence. Where at the end of the trial, they have failed to do that. They had to prove to you that he understood the risks he was taking. They didn't. Members of the jury, we agree Mr. Birdie was overweight, over that weight limit. We agree he should have, the 230 pounds, we agree. But members of the jury, we know that doesn't matter. Because we told you over and over again that that weight limit, that rope can handle up to 275 pounds. It doesn't matter if Mr. Birdie was 5, 10, 25, 50 pounds over that weight limit. If that rope was replaced, he'd still be with us today. He'd be whole today. He'd be able to walk his wife, Miss Katz, down the aisle in a few months when they're going to get married. But we just don't know if he'll be able to do that. Remember, you can't assume a risk you don't know about. That's why you have to find this defendant liable for negligence. Because they just didn't replace the rope. Thank you.
Defense closing, please.
He wanted to redeem himself. So he took the risk. And you know, opposing counsel's right. He's not going to be able to walk down that aisle. And it's tragic and it's horrible. But this case about that rope, you see, Mr. Alfonso, he's really good at using imagery. I got to give him that. Talked about a chandelier. Said if you didn't know if the rope was safe or not, right? But that's not what this case is. Because everybody agrees the one thing we all know, the one thing we don't need to question, is that the chandelier was overweight. It's that when he stepped up to go do the drop of death, he knew he was overweight. He knew he was 230 pounds. It didn't matter whether or not that rope was safe. It became unsafe the moment he took the risk. And there's two burdens going on in this trial. Let's take them one at a time. Let's start with the plaintiffs. See, when they walked in, they had to prove to you more likely than not, my company, they were so unreasonable. Human yo-yo. So ridiculous that no other company would have done that. And they showed you two facts to walk you through. Let's go through them. First, that the rope was unsafe. Like I said, they're right. It was unsafe. The moment he walked up and knew his weight, he was over the weight limit. And that's the thing, members of the jury. When you're over the weight limit of something, you don't just go over it and still do it. Think about a roller coaster. They usually have height limits. If it says 5'5" and a kid's 5'4", you don't let the kid go. You know why? Because that's dangerous. Because there's signs that tell you you shouldn't do it. In fact, we called the instructor to the stand today, and he told you himself that when it came to that rope, he replaced it. Just because they didn't have that paper doesn't mean they didn't replace it. And that brings us to their second fact they told you about. But the manager was uncertified. And this one's really interesting. Because members of the jury, you know what happens with our driver's license every now and then? You know, we forget to get them recertified. But does that mean when we're on the road, we all of a sudden forget how to make a left turn and a right turn and to put on our blinkers? Members of the jury, we still have all that knowledge. In fact, today, you heard from him. He walked him up properly. He strapped him up properly. No problems with that. But the rope. The rope he knew he was overweight for. And members of the jury, they didn't meet their burden. But you know, in the case you thought they did, it actually doesn't matter. See, just like Mr. Alfonso told you, we brought on an affirmative defense of our own, known as assumption of risk. You see, today, you can actually believe the plaintiff met their burden. But if you believe the defense did too, it's actually the defense that prevails. And today we showed you that through assumption of risk. So let's take those three facts that I told you about one by one. The first, that he was over the weight limit, and I've harped on this a lot. Members of the jury, he just was. I mean, 230 pounds, that's not the weight he told them. He told them 9 pounds underneath that. In fact, his fiance had to take the stand and tell you she knew he was overweight as well. And that brings us to the second one. He knew he was overweight. Members of the jury, we know this because of one moment that his fiance highlighted. It's when he walks up to do the drop of death. And in front of him, it's the drop. And behind him, his fiance. And they ask him, hey, what's your weight limit? We need to write it down on the waiver form. He doesn't say, oh, I can't jump today. I'm actually a little bit over. I can come back in a couple weeks. He doesn't say, hey, not this time. I'm just going to let my fiance go. Members of the jury, he steps forward and takes that risk. In fact, we know he accepted those risks, appreciated those risks, because he signed that waiver form. If we could get that waiver form pulled up for you guys. Members of the jury, looking at this form, says exactly what we've been telling you all trial, assumption of risk. Knowing that this bungee jump was 300 feet, that you know the risks that are included into it. And this second one is so crucial. I waive all claims against the human yo-yo, its staff and affiliates for negligence. They came in the court today and sued us for something they waived. Members of the jury, this can't be any more clear than this. They signed a waiver knowing they couldn't do this, and they still are here today. We could take that down. It's almost negligent of them for not reading the full form. Brings us to that third fact. And he jumped anyway. We know he did, and it was horrible. And Mr. Alfonso, he didn't want to talk about why. Said it didn't really matter, said it's not that compelling. But then I got a chance to speak with his fiance. She told me something. She told me that the first time they met, he ran up to her, he tagged her, and he said, "Racia." It's as good as it gets. But she also told you he said it once more to her. Right before he jumped. Right after he hesitated. When he's looking forward at redemption, for losing that weight, for recovery, for being with his wife, and he's looking back at the risk that he needs to take for this, and he's thinking, if I just say right now that I'm 4 pounds under, if I say I'm 4 pounds under, I could go on this jump and it's going to be okay. And members of the jury, he took that risk. It wasn't just about the jump, it was about everything. He raced off to it. He wanted to be redeemed. So he took the risk. And look, members of the jury, I'm done. See, when I sit down, I'm not going to be able to come back up here like Mr. Alfonso. This trial's over. You're not going to hear any more evidence. All you're going to be able to go back into that jury deliberation room is the 230 pounds weight he lied about. And the sign that told him. And his wife's testimony. Saying ratio. Members of the jury, he took the risk. So we're going to ask that you don't when you jury deliberate. We ask you to find him not liable. Thank you.
Rebuttal? Yes, Your Honor, may I proceed?
Please.
Mr. Muldrow wants to make this trial about that contract. Let's do it. I'm game. Members jury, that screenshot he showed you, he cropped the key of this whole trial out. He talked about Mr. Birdie's obligations. Didn't mention the defendants. Manager, you'll get to see it says clear as day. The defendant's responsibilities: provide complementary equipment and certified instructors. They didn't. It doesn't matter if you're 5'5" and it's 5'4" to ride a roller coaster. If that roller coaster crashes because the company didn't tell you that, hey, there's no more rails after that last loop-de-loop. This trial, it's not about a person's weight. It's about the rope. And they chose to not replace that rope. Find him liable for doing just that. Thank you.
Thank you all. Can we get the advocates and the witnesses on screen? A big round of applause to everyone from Plaintiff. We've got Kole, Alfonso, Miss Hannah Lay from the defense, Mr. Nasier, Muldrow, Dyllan, Balassi. Thank you so much. I'm going to turn off the recording for one moment as the judges finish their deliberations and submit. Then we'll get comments from judges and the announcement. Fantastic round. Let's get one key takeaway, one learning moment from every judge here. We'll start with Jackson.
All right. I don't know. I'm not gonna give any negative feedback because half these people are probably gonna, coach me next year or something. So I'll just say that I think that the choice of the defense witness, that it ended up being like very close to the plaintiff fact structure, kind of made it so that, like, if it was a real trial, it would really come down to just who wins that reliability battle. And I do always like to see teams betting on themselves by doing things like that, and trying to win just straight up by being better than the other team. So I'd like to see that strategy.
Thank you, Jackson. Daniel.
I think it was amazing to see a trial that really came down to the law of it, and that was so well argued on both sides of this case. Just really great to see and like learn from.
Thanks so much, Daniel. Ayaan?
Yeah, I think this round really, really just came down to who could argue it better. And you guys were both, it was a really, really close round. I really liked one thing in particular was how well you guys incorporated your themes like throughout your whole presentation. I think that was really solid. So yeah, that's my biggest thing.
Thank you, Michie.
I'm not going to give a substantive comment, but I think that this round just encapsulates when you love something so much and work as hard as I know every person who competed does at this activity, that it pays off. So it was amazing.
Abby.
I think my learning moment was on the plaintiff cross. Nasier, like towards the end of your cross, you sort of took the moment. You're very responsive. You took Hannah's racia, which was my favorite part of the direct, and you sort of made it this very emotional moment on cross. And I think it's a really good teaching moment for like being responsive, but actually using it in your favor instead of just pointing to something that happened earlier in trial.
Thank you, Vivian.
You guys are all really passionate about what you guys do. Really like the responsiveness coming out of this trial. And great job.
And Kaden.
I really love the narratives in these two openings because sometimes, you get a case, there's a lot of facts, judges don't know what's going on. I felt fully after these openings, I understood, I was being told a very clear story, who's who, what's what. I thought those opening narratives were awesome.
This was a delight to watch. As difficult as it was to roll on all of those objections, thank you so much for guiding me through them. Okay, we have 3 announcements. The first is for the MVP attorney. It was a 4-3 decision on the MVP attorney. Congratulations, by 1 vote, the plaintiff, Kole Alfonso. For the MVP witness, it was a 4-3 decision. Congratulations, by 1 vote, the defense, Dyllan Balassi. Now you might be thinking, is this going to be a 4-3 round? The first 2 ballots came in. They were a 1-point margin for the plaintiff. The next 2 ballots, a 1-point margin for the defense. The next 2 ballots were a tie That means this round, as befits a great round of mock trial, was decided by 1 point on 1 ballot. Congratulations to both teams. But in the showcase final round of the IMT Flash Trial Alumni Competition, the winners are the Defense B Team 2023. Congratulations to everyone. Amazing, amazing round. And that's just the first, baby. We got more of these in the years to come.